So let me begin with welcomes and with an acknowledgement that we are joining you here from the Diplomacy Training Programme on the lands of the Bidjigal people of the Eora Nation. And let me pay my respects to the traditional owners, past and present, and to acknowledge that their efforts and struggles for self-determination continue, that we're on unceded land. And also to note that the focus of today's webinar on the OECD Guidelines on Multinational Enterprises for Responsible Business Conduct are particularly relevant to Indigenous peoples. So in saying welcome, I should say it's very nice to see lots of familiar faces who are joining us this afternoon. People who have friends who've been through many of the diplomacy training programs, but for some of you who are not so familiar with our work, I thought I'd just offer a very brief introduction to say that the Diplomacy Training Program is an NGO, a non-governmental organisation. It's affiliated with the Faculty of Law and Justice and has a home at the Faculty of Law and Justice at the University of New South Wales. We were established to build the knowledge, the skills and the networks of human rights defenders, of Indigenous people's rights defenders over 35 years ago now, by President Jose Ramos Horta and an academic from the university, Professor Garth Netheim. We have now over 3,500 alumni of our capacity building programs over the years, and we're very proud to be associated with the work that they do on the ground for human rights. A major focus of our work, particularly over the last 20 years, has been to focus on the human rights responsibilities of companies, to have a focus on human rights and business. And as part of that work, we have had a focus over the years on a set of guidelines, the OECD Guidelines on Multinational Enterprises. And I think I was just reflecting with the colleagues who've joined us today from the Australian National Contact Point, the complaints mechanism for those guidelines, that when we began this work 20 years ago, this focus on the OECD guidelines, it's hard to think that we would be doing a webinar like this in partnership with them. And so I would like to acknowledge their partnership. I'd like to acknowledge the fact that the guidelines have developed a lot over the years as well, partly through the engagement and the advocacy of human rights defenders and of NGOs. And I think we'll explore that a bit further as we move through the webinar. This webinar is the first of three that we have agreed to do in partnership with the Australian National Contact Point. And I'm delighted that today we are joined by Laura Llewellyn, who leads the work of the Australian National Contact Point, which is located in Treasury of the Australian government, federal government. Laura is an economist by training and has worked across the Australian government on a wide range of topics, including human capital formation, taxation policy, and capital markets. Very unusual background, perhaps, for a focus on human rights, and we're delighted that she joins us today in her role as a lead on the NCP. We're also joined by John Southalan, who joins us from Perth in Western Australia. John is a mediator, lawyer, and academic. He's been a part-time independent examiner with the Australian National Contact Point since 2019 and has a lot of experience of dealing with cases that have been brought to the AusNCP. And he's responsible for the management and mediation of these complaints that are filed with the ANCP, and we will hear more about that from him directly. And our final speaker for today is a colleague, Pil-Kyu Hwang, a Korean lawyer who's joining us from Seoul, a very experienced human rights defender, somebody with great experience and knowledge also of using this complaints process, working with communities to protect and promote rights. So I think we've got a really great lineup for today's webinar. Just before I ask Laura to introduce the AusNCP, this acronym, I will just share a couple of housekeeping. So I think we're recording today's session. I hope that's okay with everybody. We ask everybody to be on mute. We will be sharing the links and the presentations that are being made through the presentation. So I think both Laura and John very kindly offered to share their PowerPoint presentations with you, so there's no need to do screenshots or notes as we go through. We'll send them around to everybody afterwards. We'll be sharing links in the chat. You can use the chat function of Zoom to put any questions that you have, and we'll make sure we leave plenty of time for questions and answers at the end. And we've asked PILQ to both respond to our first two speakers and then to moderate the Q&A. I think that's all. We ask people to be on mute during the presentations, and maybe then when we move into discussion, put your hand up or put your mic on and ask a question. That's grand. We hope in the spirit of the diplomacy training program's work and our approach that it's a very participatory session where people feel able to share the knowledge and experience that they have, that they also feel valued for their participation, and that we conduct the discussion in a way that helps build our understanding, but in a way that also acknowledges respect for the human rights of all of us involved. So I might then just move to you, Laura, if that's okay, to begin the introduction around the OECD guidelines and the role of the Australian National Contact Point, AusNCP.
Thanks, Patrick.
Thanks, Laura.
Great. So as an introduction, I'm speaking to you today from the lands of the Ngunnawal people. I acknowledge their ongoing connection to country and pay my respects to their elders past and present. As Patrick gave a really great, I guess, contextual introduction to the AusNCP, we're really excited about this partnership with the Diplomacy Training Program to talk a bit about the work of the Australian NCP, or AusNCP to its friends, and just more broadly, the OECD's National Contact Point mechanism more generally. So to kind of get us off with a bit of context, I'll just give you a very quick primer of what the OECD guidelines are and what NCPs are. So as you can see on the slide, the OECD guidelines are described as internationally agreed. Oh, can you go back a little bit, John? Sorry. Internationally agreed standards on responsible business conduct. They're the world's leading broad-based standard on RBC, and I'll talk a little bit more about that term in a minute. And they're directed at multinational enterprises operating in or from adhering countries. Australia is one adhering country. And importantly, there are obligations on the countries that sign up to the guidelines and the legal instrument to which they relate. And one of those is to have a complaints mechanism known as a national contact point. So I'll just go into those three kind of elements in turn. And probably a good place to start is the lingo or jargon of responsible business conduct. It might not be something that you've come across a lot. We find when we're talking to people, European stakeholders will talk about RBC. In Australia and perhaps in the country that you're from, you might hear terms like environmental, social and governance, ESG, corporate sustainability, or social responsibility. As you can see from the slide here, the type of things that the guidelines cover encompass all of those things. So you will see in the mix, it's very broad-based, but the umbrella term used in the guidelines and for national contact points is this term of responsible business conduct, or RBC. But broadly, it's about how businesses can have an impact on individuals, society, and the environment. Okay, next slide. So who do they apply to? So in the first slide, I used the language of adhering countries. And so these are countries that have signed up to the legal instrument to which the guidelines relate, and they are recommendations to multinational enterprises operating from those countries or in those countries. So you will see from the map here, the coloured area are adherent countries and the grey are non-adherent countries. And it's important to note a couple of things. If you're looking at that thinking, gosh, there's a lot of grey there, I guess there are 2 points to think about. Firstly is that a lot of activities in those grey areas will be covered by the guidelines, and there are expectations of companies operating in those jurisdictions because they're from adherent countries. And we'll look at some examples of that later when we talk about kind of the AusNCP's work. And then I guess the other point is the list of adherent countries is growing over time. So you will see there in the list that in addition to the full OECD members, there are a series of countries that are adhering to the guidelines over time because they want to, I guess, attract quality investment and economic activity to their countries. And as many of you might know, there are several countries in the Asia Pacific who are working towards OECD membership. So moving on to the final slide, which is around, I guess, contextual slide around national contact points. What are these things? What are they expected to do? You know, what can you expect to see if you go to their website or you're thinking about contacting one? I guess it has 3 primary roles. So the first is to receive complaints. It's a non-judicial grievance mechanism to resolve issues related to the guidelines. They're called in the documents specific instances. At the NCP, we just refer to them as complaints or cases because that's more intuitive and accessible for our audiences. The second major point is promoting the guidelines. So things like talking to you today, having a website, getting out and about and both communicating to businesses about the expectations and also, I guess, prospective complainants about the guidelines and the mechanism that we have available to them. The third limb is some within government work to help coordinate and I guess foster coherence of policies to promote RBC. Because you will have seen on the first slide, it's a big area, lots of different topics, and it's important to consider where there are opportunities for a common approach where it makes sense to do so. So in thinking about these binding obligations for adherent countries, and there are 52 at present, there are common criteria by which we have to do our work. So these are called the core criteria. They're on this screen. So we must operate in a manner that's visible, accessible, transparent, accountable, impartial and equitable, predictable, and compatible with the guidelines. It's important to note that countries actually do have a lot of latitude in how they structure their NCPs. So there are particular models that are more common, but countries have a lot of latitude in thinking about what makes sense for their national context. So on the screen, you'll see a bit of a snapshot. There's a link there that might be good to pursue, I guess, after the webinar if you're interested. It's the annual report on NCP activity, but it describes what the network of 52 NCPs looks like and the types of structures they have in place. Now, if you're thinking, oh, where's the AusNCP there? It's awkwardly at the bottom called hybrid, which doesn't really tell you much at all. So I'll go into a bit of structure discussion here. So you will recall that NCPs are meant to have regard to common criteria. So each NCP must decide how it structures itself accordingly. And in 2019, the AusNCP restructured itself to, I guess, as a result of a rethink about the important features for a complaints function. So broadly, there are 3 parts to the AusNCP. There's my team in Treasury. We're responsible for Australia's overall obligations. We support our independent experts, we engage internationally, and we promote the guidelines. Our next kind of limb is what we call the independent examiners, and John Southalan, who will speak to you later, is one of those. When we restructured the AusNCP, we really thought about what would be best in terms of discharging our obligations. And we decided that independent experts to handle complaints would really maximise our access to deep expertise on RBC issues. And you can have a look at the profiles of our independent examiners on our website. And it also will send a signal and provide confidence to stakeholders around impartiality, because it's not, they're not decisions of government whether to accept complaints or decisions around whether a company has breached the guidelines. And so that's the structure that we have in terms of our complaint handling. And then in terms of kind of helping us with our accountability, our transparency, we have a governance and advisory board. You can also see them on our website if you're interested, but they consist of both non-government and government stakeholders, and they provide advice to us and examiners on the management of complaints and how we can best promote the guidelines. Okay, so a bit of a snapshot. Thanks for kind of working with me through the kind of context and laying the groundwork. You'll see here, this is a map of AusNCP complaints that have been received since basically we received our first complaint. Excuse me a second. You will see here that they're both adherent countries and non-adherent countries, and it's really all over the world. Now, this isn't a record of every complaint. Some complaints have, some countries have had more than one complaint, but broadly you can see that it's all over, I guess, the world. If, I guess, kind of drilling in a little bit more closely, this is a snapshot of open, so broadly still in the active stages of a complaint handling process, or recent complaints. And you can see that there are quite a number of non-adherent countries and kind of countries across the globe. If you're interested in any one of these, thinking, I wonder about that one, you can find some information on our complaint kind of tracking on our website, and the link is there on the screen. In terms of kind of broader NCP network complaints, because I realise we've got people from multiple countries here, it might be that an issue or a concern you have relates to an Australian company or another company. You might want to just get a feel for how things look at a network level. So as you can see here, submitters of complaints are generally individuals or NGOs. And that's quite common in the Australian context as well. We don't generally see as many trade union complaints, but many NCPs do. And the kind of industries that we're seeing, you know, it's across the board, but finance and insurance is very, very common, perhaps because, you know, they're part of the value chain. In the Australian context, we do see quite a few mining related complaints. Okay, the type of issues we see. So you might recall from the earlier slide that it's a very broad kind of set of issues. And generally what we would see is that complaints will relate to multiple issues. And that, you know, is pretty typical given the interconnectedness of some RBC kind of policies. So you'd see human rights and environmental issues, for example. And typically this is kind of network snapshot, but we do see a lot of human rights related complaints to the NCP, and they're often coupled with environmental related complaints as well. Okay, so that's the kind of quick snapshot around the NCP network, the AusNCP. The other part of what we do, which I just briefly wanted to touch on, and is probably the start of a longer conversation with you, is the work that we do to promote the function and to promote responsible business conduct. So this is part of our obligation. And we do this in a number of ways. So you can see on the screen there, it's multi-kind of channel. We speak to stakeholders like this. We have websites, we use social media, we try and utilize other areas of government, but we're really keen to hear from, the people who we're trying to reach, such as yourself, on what you think might be effective going forward. So I guess I'd like to kind of give you an open invitation. If you have any ideas or you're wondering, why don't they do this or that? Please, we're very keen to hear from you on how we can improve and how we can kind of increase the visibility of the work of the AusNCP. Right, next slide.
Is me, I think.
Yeah, thanks, John.
Thanks a lot, Laura. So there'll be an opportunity to ask questions of Laura later and myself, but we thought, given what Laura explained about the differences between the different roles in the AusNCP, I'll take some time to really focus on the complaints process. So before I start that, I also wish to acknowledge I'm on Whadjuk Budjar or Noongar country in the southwest of Australia, and pay my respects to Noongar elders past and present. There's 3 points I guess I want to talk about in the next 15 or 20 minutes, and I'll come back and give a bit more detail on these in my final slide. But the 3 points are this. One is to understand the guidelines are not a judicial remedy mechanism. There's a lot of important and useful things you can do with the guidelines and an NCP complaint, but don't expect that this is a court that will make a binding decision that can be enforced. Because if that's what you need, don't waste your time or your community's time with the NCP process. The second point is I want to spend a lot of time on how to make that NCP process work well for the complainant, for the communities, for the people who have concerns about harm and the parties. And then just a couple of quick slides at the end about some useful databases and ideas. As Patrick explained, all these slides will be made available later. And so a couple of these I'm going to go through very, very quickly, just so that you know what's in there. So Laura explained the context. If you want to know what's the actual document or what's the page number or what's the reference number, this one shows you. So the guidelines come from an international instrument, this 1976 declaration. So they're an attachment or an annexure to that. And you see sort of the key points in there about having to set up a contact point, as Laura was saying. That's an obligation, and there's the reference you can find for it. I don't want to get into the guidelines. Probably just one point I think is useful to reinforce, and it's the question of this relationship with the law or the regulation in a country. And to reinforce, the guidelines say here, and sorry, I'll show this a bit bigger. The guidelines, you see this important point here that they say it doesn't matter if the local law in that country does not meet the international standard. If a company can meet the international standard, then it must do that. To take one example from Australia, we have law here that says when a new, say, mining development or a new proposal is going to occur, they must talk with the Indigenous community about that first. There is compulsory engagement. You cannot start that process without 6 months at least of talking with that community. And sometimes agreement will occur, but the Australian law does not say you must get agreement. And where there's going to be a very serious impact on that community, the international standards do expect there should be the consent of that community. And so this would be an example where in Australia it would say, okay, company, you've met the local law, you've engaged, but in this instance, you're expected to get to an agreement. And in this case, the guidelines would say there's that expectation to go further and meet the international standards. The OECD have put out a number of useful documents about particular sectors. So if you're working on, say, agricultural issues, I'd really recommend finding their guidance. And when you get these slides, these are all internet links. So you can click on that and it will go to the document. So I don't want to spend a lot of time on that. Just one point, I guess, I want to reinforce, and it's probably a concept a lot of people have heard about, this idea of due diligence. Human rights due diligence, or due diligence about impacts. The OECD guidelines and these guidances explain how that works. And it's that concept that we often see referred to and central in the complaints process. And that's really what I want to spend the rest of my time talking about. How does this complaints process work? And often it's a discussion about what has the company done, or what can the company do to meet those due diligence expectations? So what I want to spend a bit of time on is just looking at the complaints process in general, so you're familiar with how that works, and then look at some particular examples or more detail of how this works in relation to the Australian National Contact Point. So the first point is this: they have a concept or a stage called initial assessment. So when a complaint is received by a contact point, the contact point must do this thing called initial assessment. It's basically sort of a check. Is this within the guidelines? Is it about a company that's covered by the guidelines? So if your concern is this government or this government agency is not doing the right thing, that's not something the guidelines addresses. The guidelines are about responsible business conduct. So you need to explain what's the business involved, what's the connection with the business, and you can see the 6 criteria that you must, I guess, convince and show a national contact point when you put in a complaint. And we can come back to this in discussion if you want to talk a bit more about that. But when a contact point gets it, makes this initial assessment, if they say, yeah, there's enough information here, we're not saying the company is breached or is wrong, but we accept the complaint, and then they use this phrase, and I'm sorry, good officers. There are a number of phrases in here that aren't always really logical. Good officers, essentially a dialogue, a mediation, a way to resolve the particular issues that have been raised. And if you look at the guidelines, they explain, so it says if initial assessment is passed, or the NCP accepts the complaint, they offer good officers. There's the wording there. It's a consensual, it's a forum for the NCP to try and help the parties talk about and engage about that issue. And it's very flexible. And often the NCPs will say, okay, let's get some procedural agreement about how the parties are prepared to talk with each other. Maybe it's about confidentiality, maybe it's about who's involved, where it will occur, things like that. So there is a flexibility, and we'll look at some examples in that. So the first stage, the initial assessment, then the good officers is really, I guess, the engine room of that. And I want to spend a little bit of time on this. How does that work? Because it's essential to understand this if you really want to get some useful and effective outcomes. So good officers, as I said, it's often a mediation. So bear with me. I want to spend a minute just talking about mediation. So mediation, generally an idea of getting parties together, and we can understand parties. They'll often make statements. Oh, you've done the wrong thing, or this is what's happened. And in a mediation, it'll be more, okay, that's brought us here, but really we want to understand what's your interests, what are your needs, because it's trying to find something that might not be the best outcome for everyone, but something that both parties can share that idea of, okay, what are some common interests or needs there? That's it generally. Let's sort of have an idea. what might that look like if there's a complaint from a community, let's say about mining? So you might have statements. The community will say, look, there's been mining here for 10 years or more, and it's always, there's impacts and it's harming us, and it's never been remedied. They never clean up. We don't get benefits out of it. You might get those statements. On the company side, you'll often hear, we've got permission to do this. We've spoken with the capital city. They've given us the mineral right. We're allowed. We've got, under the law, we're allowed to do this. That's another statement. The community might say, look, we just, there's no mining. We oppose all mining. There can be no mining that occur here. That's a statement. Again, you know, the company might be saying, look, your position was considered when the government had a process and they looked at your concerns and they still gave us our permit. So there's all these statements, and they might be valid statements, but if you're wanting to get these parties together, the mediator will be saying, let's not focus so much on the statements. Let's start looking at and help the parties understand each other, explain what are their interests. So here it might be on the community side, well, they want to be involved in these decisions. They don't just want decisions made by the capital city 500 kilometres away. The company, they don't want bad relations with the community. They want to find to have good community relations. They want to find a way to do their process, minimising the impacts. And then perhaps if we get deeper down again, what are the needs? You know, and we could understand that. Well, the community, they want a healthy environment. They don't want this dangerous situation. They want a future for their community. So you can see ways in which how that good officers, that mediation process will be encouraging the parties to engage on that. And I want to really stop on that and reinforce that, because that will occur within the guidelines, and it might be that everything that you can find of that common interest is within the guidelines, or it might be that only a little bit of that is within the guidelines. But still, there's a mediation, and I'll talk about this. It might be that perhaps there's a way that the parties can come to an agreement on something that's not even required by the guidelines, but the process has enabled that agreement. And I'll come back to a good example of that. So very broadly, that's what you often expect in this good officers process, a dialogue, a mediation. And the importance to understand this here, sorry, this slide is a bit messy. What I've done is I've just got some images from an NGO called OECD Watch. They do a lot of work on how to use the NCP complaints process. And they have, well, what could come out of the complaints process? And they say there's all these different examples. And so I've grouped them together. The NCP will make a statement, and maybe the statement will say, this is what the company should do better, or the company hasn't done the right thing, maybe. So you get a statement there. It might lead to action by other parties. So it might be after the NCP statement, maybe the media will give further publicity to it, or maybe an investor will say, well, we don't want to be associated with that issue. And OECD Watch say there's also, I guess, solidarity and strengthened links between civil society. I agree, these are all useful outcomes, but my guess is for a community who's maybe impacted by what a company is doing, if you look at those things, probably the community would say that's not really helping us. That's not addressing that harm. And so yes, there are many other examples we can point to of outcomes that address harm. And here, just a couple, I make it a little bit bigger. You know, the company might issue an apology. There are a couple of examples where the company has paid money and compensation, or has taken action to rehabilitate some of the damage. So there are those examples there. The key thing I would say there, and you see it at the bottom of this slide, the only way in which you get direct action from a company through this good officers is with the company's agreement. So all those possibilities from the company, it's where that mediation has worked that you've found some way that the company says, actually, yeah, we want to agree that aspect and reach that. And that's an important thing to bear in mind as to what we're trying to do in good officers. So let me go a bit quicker. There has to be a final statement, regardless of however you've got through this process, the NCP must make a final statement. So it might be the final statement is, oh, this didn't make it through initial assessment and this is why, or it might be the parties came to an agreement. And depending on the parties, some of that may be confidential between them, some of it may be explained. And if the parties haven't reached agreement, often the contact point may make its own observations and recommendations. So that's the complaints process very broadly. What I want to do now is say, well, how does this work for the AusNCP? And there are a couple of, I guess, differences and a couple of areas in which there's even more detail. So there's 5 points I want to quickly finish on. One is this, you remember me talking about this phrase, good officers. If you pick up our procedures in the AusNCP, that's called dispute resolution, trying to help the parties resolve their dispute. So that's just a terminology thing. But there's really four other points I want to spend a little bit of time on. And I'll go through these. And for each of them, you can see I've referred to the actual paragraphs in our procedures if you're interested in that. So the first point to make is when the complaint is first made to the NCP, there's a submission that's received by Laura and her team. Our procedures say that the Secretariat, Laura's team, have to work with the person who's made in the complaint. It says in the procedures they must ensure accessibility. So sometimes that might be help with translation. Sometimes if the complainant finds it difficult to use the website form, then we'll say, well, okay, can use email or other ways in which you can provide the important information. We might refer them to people who can help with this, so OECD Watch or NGOs expertise in Australia. And the procedures say they must work with the notifier. They're not acting on behalf of the notifier, but they're explaining, look, this is the kind of information you need to show for this to get to initial assessment. The second point I want to talk about is, well, what happens if there isn't agreement? And our procedures have a lot of detail about this role of examination. So that really sits there in two instances. Either the company says, we're not interested in engaging, and our procedure will say, okay, that's fine. This is now going to go, and the independent examiner will look at this and make a statement about whether they think you're meeting the guidelines or not. Or if it's gone into good officers, gone into dispute resolution, and there hasn't been agreement, then it will also go to examination. The final statement process, again, I'm going quickly, but I just want to show you what's in there in our procedures. It says the issues that have to be talked about in that final statement. And then the last point is an interesting one. It's one that we've used, I think, well within the AusNCP. There's a process called follow-up. So NCPs, they might make their statement, they make recommendations, and in 12 months' time, they'll say to the parties, okay, what's happened here? Has that been addressed? And in our procedures, it says at that stage, there can also be more engagement between the parties. So essentially go back into mediation and engagement. And it's been a very useful point that we've used. So I realize that that's quick. And for this next slide, I won't spend a lot of time, but when you get the details, what I've done is for each stage, I've given some examples. And so you can click on that, it will show you the decision. So we've got examples where the parties have come to agreement through the good officers or through the follow-up. There've been examples where the complaint was submitted and during that initial assessment process, the company have said, actually, we want to engage with the complainant and try and address this process before the NCP even needs to deal with it. So we've got some examples where if you look at the statement, you see that that's what happened there. This one I think is important to look at examples where complaints were not, I guess, didn't pass the initial assessment. There would be various reasons why. Maybe there was not enough information provided, or that the company was doing everything that was pointed to was consistent with the guidelines. So there's some useful examples there, I guess, to see what do you need to show to persuade or show that you should pass the initial assessment process and proceed within the AusNCP process. And again, I won't spend too much time here. In the final statement, you can see various examples where there hasn't been agreement. There'll be recommendations about what maybe the company needs to do, or also places where, having looked at it all, the independent examiner's view is, well, in this instance, these things the company is doing is consistent with the guidelines. And Laura mentioned earlier, we have a governance and advisory board, and they have a very important role. When a final statement is made, the first thing that the examiner does, they draft it, and it goes to our governance and advisory board. And I think I've seen at least one of our colleagues is on this call. They look at it and they give feedback and advice to the examiner to make sure that we're thinking of all the correct issues under the guidelines. A couple of quick slides and then I'll finish. There are various databases of cases. So they're very useful to look at what's happened in here and get some ideas. The OECD Watch I mentioned before, I'll say it again, excellent websites. And this particular slide and that URL there, a lot of strategic thinking about, okay, is an NCP complaint what you should be doing, and how would you go about that? What material would you get? How should you engage in mediation? And then let me finish to go back to the 3 points I opened with. So it's not a judicial remedy mechanism, and the focus has to be on business. So it might be, oh, the government's doing, the government in this process is allowing these impacts, but there your complaint should be the business isn't doing anything about those impacts. The business isn't using or isn't meeting its due diligence obligations. If you frame it as the government's simply allowing these impacts, an NCP will say this isn't something we can help with. Factors outside or different factors can contribute to that outcome. And that point I was making, you need the best outcomes. The immediate action from the company is where you can find a way to get to that agreement. And then the final point, look at those databases. If you're making or considering a complaint to an NCP, what are their particular procedures? Have a look at that. Have a look at their recent statements, because they're very useful things to look at as well. And I'll finish there and very happy to take questions or hear the further discussion. Thank you.
Thank you very much, John, and thank you very much, Laura. It's terrific presentations, I think, very complimentary, both looking at what the guidelines are, what the AusNCP is, and then how does it work in practice through the role of the independent examiners, of which John is one, who brings great experience, as we've heard, to this. A very clear exposition, I think, of the way the guidelines have developed and way they operate in relation to Australian companies. And I should also take the opportunity here to acknowledge that we do have a member of the advisory board in our guests here participating today. So, and also a great friend of the diplomacy training program, one of our very expert and wonderful trainers on our program. So will be familiar to some of you, I think, as well. But to acknowledge here, Serena Lillywhite. So lovely to see you here, Serena. And please do feel free to join into the chat if you feel that you would like to as we move on. It's a pleasure now for me to introduce Bill Q, who is, we are very proud to say, an alumnus of the diplomacy training program. We first met, I think, in one of our business and human rights programs, one of our first business and human rights programs many years ago in Indonesia. And Bill Q works across the region, working with communities on business and human rights cases, among many other things, including with Indigenous peoples and on the rights of migrant workers, and has also engaged with the Korean National Contact Point. So we thought it'd be very helpful to hear Bill Q's response to what he's heard, to share his own experiences of engaging with the process, and then to draw out any of the key points, elements of the presentations that we've heard from, and then to facilitate the discussion. And we've seen, I think, already on the chat, some really good questions. And I would encourage others now to also put your questions in the chat to help us in this final half an hour of the webinar. In fact, we have, I think, 40 minutes still, so that's great to have that amount of time. Phil Q, if I can pass over the microphone to you, I'd be honored. Thank you.
Thank you, Patrick, and thank you so much, Laura and John, for your insightful and informative presentations. I work with this organization called Gongam Human Rights Law Foundation. It's a nonprofit, full-time human rights lawyers group in South Korea. And we are part of this coalition called KTNC Watch, which is monitoring Korean companies overseas and the human rights violations outside. And concerning these NCP procedures, we've been submitting a number of cases to Korean NCP and other NCPs. And so, for examples of these cases are first, a crackdown of a labor union in an economic processing zone in the Philippines by Philzone, a Korean manufacturing firm. Second example will be deprivation of land rights of forest dwellers to pave the way for a steel plant in India by POSCO, a Korean company. And third example is a man-made disaster of collapse of a dam built by SKENC in Laos, which killed more than 70 people and badly affected thousands of villagers. So overall, I mean, the NCP procedure, since it's a voluntary process, even the government is not doing its job or companies doing nothing, there is hardly any way to force the government or companies to become more serious about this whole procedure. But experience from our 20 years of experience, sometimes we realize it's very important to never give up and continue to mobilize this kind of grievance mechanisms, and things have been changed at least a bit. So I have more questions than comments. So concerning submission procedures, I think it's important to find and work with reliable partner organizations in other countries related, especially to do with the supply chains. I mean, a factory in the Philippines and a Korean headquarters, the company's headquarters in South Korea. So it's important to have a very close kind of collaboration between the NGOs or labor unions or the communities in both countries. So my question is, did the Australian NCPs see many cases where Australian and other countries' organizations could submit complaints? And in those cases, did you see some kind of added value of this kind of collaboration? That will be my first question. And concerning the Korean NCP, I mean, you can submit complaints either in Korean or English, but there is no translation services provided. And I think that John mentioned about this, or Laura mentioned about this, some translation support, but to what extent is translation provided at the AusNCP? That'll be my second question. Concerning initial assessment, in Korean NCP, we submit the complaint, and after receiving the company's replies, we can submit additional documents. But there is no process of hearing or interview whatsoever, even when we insist, strongly ask for this kind of interview or in-person contact to talk about the case. So my question is, what's the whole process of case analysis at the AusNCP? I mean, is it possible for stakeholders to be interviewed, or are they given enough opportunities to submit counter arguments? And concerning good offices, in Korea so far, if companies are passive or withdraw from the good office procedures, the Korean NCP didn't give recommendations applying the OECD guidelines. The best one we've got so far was the NCP asked in the final statement, it asked the companies to be engaged with the stakeholders or complainants. So my question will be, in the AusNCP, do you very often make recommendations in the final statement, actually applying the OECD guidelines? It's against our guidelines, or you should stick to these provisions of guidelines, things like that. And concerning AusNCP, yeah, I mean, I've seen the profiles of, including John's, of the independent examiners, and I think that they are really qualified. But who decides? I mean, who appoints these independent examiners will be very important. And it seems they are not full-time, but are they full-time or not? And are there full-time staff support when you do case analysis? And even though you are, kind of experienced human rights lawyer, some people, can be, not experts on, the OECD guidelines. So do you get training before you start to work as independent examiners? And beside this innate, limitations as a non-judicial voluntary mechanism, how do you see the strengths and weaknesses of AusNCP in resolving a case? And my final question will be, can you introduce an exemplary case where complainants received satisfactory results? And what do you think the factors that made it possible? Thank you.
Thank you so much, Patrick. How do you want to do this? I've some answers. Laura's is better placed to answer some as well. Do you want us to take a number of questions? I've been making notes, or what's useful?
I think it might be helpful for both of you just to sort of tag team on these questions that Bill Q has put in the first instance. I think if you haven't got any of them down, we can come back to them. But I think maybe just take those in order, and then there have been a number of very interesting and helpful questions on the chat too that it would be good to get to. But I think if we start with Bill Q's questions, which I think are very informed by his own practice and seeing there, and I think the contrast between the two is really interesting to draw out also, because I think some of us have memories of the AusNCP when it was much more like what the Korean NCP is currently. And so it's interesting that sense of how the complaints mechanism has evolved, I think would be very interesting to share as of your insights for both of you, both the technically, and then I think the grounding in real experience is very valuable to share.
Sure.
Okay. John, Laura, I've been writing some down. I don't. Hopefully, I've captured a lot of them, but I might just group them in kind of common themes. So I guess one of the first questions was about governance, and John is here. We have examiners on our website. How do they become AusNCP independent examiners? So Treasury, it's my team's job to manage the relationships with examiners. We go through a competitive process to appoint our examiners. So we did a public tender that was widely advertised, and anyone who was interested in becoming an independent examiner could submit through that process. And it was a process that we ran through consistent with our Commonwealth rules, with interviews and referees and those things. And I guess there are many criteria that we think about when we think about, independent examiners. Expertise in the issues covered by the guidelines are one. Our examiners' ability to, foster a dialogue between the parties and sensitively manage things with the parties is another. Most of our examiners are also qualified mediators, and there have been a number of examples where we have facilitated a mediation qualification for our examiners, but it certainly is a process where we take that selection process very seriously, and then examiners are appointed after a merits-based process. There was a question about, are examiners full-time? What are the terms in which we employ them? They're not full-time. Generally, we find a couple of things. One is getting access to this expertise is actually really valuable, and often the people with this expertise are working in a number of ways. So they might be a barrister, or they might be a mediator, And it suits them and it suits us quite well to work on a part-time basis as needed. And we have, I guess, variable hours. And our experience has been that we are able to manage, I guess, handling our complaints in a timely way with that part-time examiner arrangement. We have 4 part-time examiners, but my team, and there are a number of us on the call, are full-time. So there is always an interface available for complainants and doing promotion and other work that is full-time, and then we work flexibly with our examiners based on, you know, the rhythms of the complaints that they're working on. That was the first question.
Perhaps,
also,
Laura,
yeah.
can I just, one thing on that, I guess on capacity and experience is again to reinforce the board, the governance and advisory board, because as I said, any draft decision an examiner makes, it goes to the board. And I'm not going to talk about particular examples, but the process in general, on that board, we've got people from union background, civil society background, business, finance. And so I can tell you it's a very rigorous process. The decision goes up, and often, and Serena may be able to talk to this, the governance advisory board will come back and say, well, what about this aspect of the guidelines? Or why are you saying that? Or so we get a lot of useful experience in that as well. Sorry, Laura.
No, that's a good point, John. One of the other questions was around the type of complaints we see and whether we see NGOs partnering. So from the AusNCP perspective, that is a very common model that we see. We will have an NGO that's based in a country where the alleged harm is occurring, and that might be a non-adherent country or another country altogether, and they will partner with another NGO, sometimes a group of NGOs in that country, or also an Australian NGO. So if you have a look at our complaints tracker, which the link was in the chat, you will see just even on the summary page, there's a list of notifiers. You will see that a number of our current complaints have got a mix of kind of in-country NGOs and then an Australian NGO. And we've had examples where there might be we've had an example where there was an Irish NGO leading on behalf of NGOs in Colombia, for example. And I guess I mean, the notifiers in those complaints can speak to the benefits of that, but certainly from our perspective, it provides a good mix of information directly about what is happening on the ground and the issues and the impacts, but also some greater familiarity with the NCP mechanism to help navigate the process and provide a bit more capacity that critical mass can provide. John, do you have any thoughts on that one? Or
I think just one thing to add to that, always really useful to have an NGO or someone familiar with the place of where the impacts are occurring, because the whole idea of that, good officers of that engagement, of understanding what's occurring and how that can be addressed. If it's just someone in another country who says, I'm not happy about this, it's going to be very hard for that to be a useful engagement.
Yep. There was a question on translation services, and I guess this goes to our accessibility. So we have a complaints form on our website, which is in English. We do have capacity for prospective notifiers to get in touch with us if they need help. From time to time, there's occasions where we've received emails or submissions where it appears that English is a second language, and we have used a translation service to actually send back advice to them in their first language so that they understand the process. We really do take it on a case-by-case basis. It does depend on the circumstances, including, for example, whether there's a mix of Australian NGO and other country NGOs. But we have on our website, if you're looking at the complaints tracker, there's one related to Mallee resources, which is an open complaint, and you will see that there's an executive summary in Burmese for that, for example, and we've utilised translators on occasion to help the notifiers for that complaint kind of communicate and engage as part of that process.
And also during the good offices as well, in one of the complaints, the AusNCP funded a translation service to help with the engagement because there were many different parties as well.
There was also a question about what you might expect to see in a final statement from the AusNCP. Do we make recommendations to companies to improve their adherence of the guidelines or make determinations about whether the conduct was consistent with the guidelines? The answer is yes. Whenever a complaint goes to examination, and as John touched on, either it's because the company declined mediation or good offices, dispute resolution, as the lingo goes, or if there wasn't a resolution through that, it goes through an examination process where the parties can put forward their views and submissions. And importantly, those submissions are shared with each other for procedural fairness, which kind of goes to one of the other questions about, do you have an opportunity to provide supporting documentation? How do I know what the other side is putting in? Do I have, can I object to that? It's an important part of our process, that procedural fairness and sharing of information. And once that process kind of is finalised, the examiner is empowered to make both a judgment in the final statement about whether the company's actions are consistent with the guidelines and also recommendations for improvement. And I would say that that is extremely common. And in fact, there's an example on our website where an examiner gave a recommendation to us, the AusNCP, for us to improve our engagement with Australian companies overseas. So it's very common and an important part of, I guess, the final statement process, certainly in the complaints that we're handling. John, did you have anything to add on that one?
No, I think that's covered it.
I'm just having a look to see what have we missed in terms of that list of complaints, or list of questions, sorry. So
Laura, it's Serena here. I might just jump in while you're having a quick scan of that. I was just going to add in response to Piku's questions around the structure of the Australian NCP and the Governance Board. One point to add is that we have a very rigorous process to track any conflicts of interest, either real or perceived conflicts of interest. We have the Laura's team maintains a register of interest. And we have in fact had cases where, for example, one or more of the independent examiners may have felt that they've had a engagement with a close engagement with that particular issue or case. And so having this, if you like, small team of independent examiners does give great flexibility to ensure that if there is either a real or a perceived conflict of interest, then Laura's team can manage which independent examiner is best placed to deal with that. And so it's a really good way of trying to meet that criteria of fairness and impartiality. And that also applies to the Governance Advisory Board. And we have a proxy system as well, which means that if one member of the Governance Advisory Board for example, actually submits a case, and there is a case involving Papua New Guinea at the moment where one of the organisations on the Governance Advisory Board has actually raised the case. So they can't comment on the final statement that is put out as a draft final statement. So we have a proxy system whereby as somebody else in that particular case, I'm the proxy, I can step in and ensure that there's still the criteria of a very rigorous review, even of the decisions or recommendations by the independent examiners, is upheld. So I just wanted to add that to what John and Laura have said, to perhaps help you, Piku, in terms of understanding the governance structure of the Australian NCP and how it really has improved out of sight over the last few years.
Thanks. And I noticed the last question you asked, Pilku, was an example of a case, and I've just put that in the chat. So this is a complaint against an Australian bank for its financing and support of some work in Cambodia. And it's quite an interesting example where there was mediation, there wasn't an agreed outcome, and the AusNCP statement, if you click on there, you can see the final statement. The final statement said, they don't think the bank has done enough for its due diligence. It didn't check properly, made some recommendations and said, we will follow up in 12 months' time. And in that follow-up, the bank said, we would like to talk to these complainants again. And there was further mediation and there was an agreed outcome. And so if you look on that page, you can see a thing called update or follow-up statement. And in that, the bank agreed all the profits that they made from that loan. They said, we understand there have been impacts. And you see in the statement, the bank said they will pay over all the profits of that loan to those communities in Cambodia. I can't go into any more detail because some of how that exactly worked is confidential between the parties. But that is a good example of two things that I say. The follow-up can be useful, and also that process got something that the law does not require. You could not find an Australian law or a Cambodian law that says the bank must pay over its profits. And in fact, it probably to some degree even goes further than the OECD guidelines requires. The guidelines don't talk about how much you have to pay. You must pay over your profits. But the particular engagement there, it was able to find, I guess, an outcome that all the parties were prepared to live with. I've spoken enough. Patrick, back to you.
Yeah, no, that's great, John. And thank you very much, Serena, also for adding. That's very, very helpful. Look, there have been some great questions in the chat, really terrific. I pick up one here from Nicholas, which is around I think the issue of I think you touched on it in your presentation, John, about the sort of relevance tension sometimes between domestic law standards and international standards. So many countries don't recognize Indigenous peoples in their law or the rights of Indigenous peoples, but the leading international standard is the UN Declaration on the Rights of Indigenous Peoples, which most governments have adopted, have agreed with. Can you explain how does that tension take place when you examine a case, or maybe also Laura? How does that play out if an Indigenous peoples organisation affected by a company says, look, UNDRIP, UN declaration, has been breached in this circumstance, FPIC hasn't been applied, etc.?
Yep, sure. I can make a couple of comments and then I'll also get the link for one decision I'd say be useful to look at. So compliance with UNDRIP, the UN Declaration on the Rights of Indigenous People, that's initially an expectation of countries, of governments. And so again, gets back to this point, I'd say be careful in framing your complaint, not to say the law here does not meet UNDRIP. The way the complaint should say is this company is engaging here in a way that is not consistent with UNDRIP, and that has impacts of human rights impacts, and that's one thing that the human rights due diligence process expects for companies to address. So I'll put the link in because we've had a good complaint where we've looked at that, and I saw an earlier question making the difference about the obligations or I guess economic development incentives, I guess, of a country. And this was an interesting example where in this statement in some detail I looked at, well, if there's some what the country thinks or the government thinks is there's general benefit, but there's some impact, and the government says that, well, we'll make that balance and that's okay. International law will say in some instances that's a legitimate, I guess, outcome and decision that the government and the country can make. But if you're a company and the impacts are so significant on Indigenous group, the standards are pretty clear. They say that that's not enough for a company. A company can't just say, oh, there's some general benefit from this project, therefore that's good enough, and I don't need to address these impacts. I'll put up the link, and I'll refer to a couple of paragraphs that might help people get to that.
Thanks, John. That's great. There's a very interesting question also from Nima from Infid in Indonesia. Indonesia is in the process of joining or becoming an OECD member country, and Siti's question goes to the sort of how do the UNGPs, the guiding principles on business and human rights, relate to the OECD guidelines, particularly, I guess, for countries that are members of the OECD. Can you speak to that complementarity or mutual reinforcement? Either of you, Laura or John, or both?
Do you want me to speak to that one, John?
Yeah, sure.
Yeah, so I mean, as we've kind of spoken about here, the OECD guidelines do have a chapter on human rights. It was introduced in 2011, and that is quite deliberately intended to align with the UNGPs, so that and that went in the 2023 update to the guidelines, which we haven't talked about, but there was a 1 in 10 year refresh of the guidelines in 2023, thinking about how the RBC landscape had changed over time. One of the things that was a very conscious decision by adherent countries and a lot of debate with stakeholders is really ensuring that that human rights chapter, and then also the general policies chapter, which talks about due diligence frameworks, it maintains that alignment with the UN guiding principles on business and human rights.
Thanks, Laura. So there are a whole number of questions that maybe I can pick up a couple. Time is running out. We've got 2 more webinars to come. I'm also very mindful that Laura asked a question of everybody also, which was, what can the Australian NCP do more to promote the guidelines to communities, to stakeholders through the region? So please share in the chat, or if you've got suggestions you'd like to share, please put your hand up. Otherwise, share in the chat. That would be great. And also, of course, very welcome to do that after this. There's a question from Shreya, which I'm not sure we've gone to, which is about whether NCPs can still reject complaints even if, after initial assessment, even if they've met all of the admissibility criteria.
Thanks. Yeah, sorry, I saw that. The 6th criteria is, would it be sort of effective in the interests of the guidelines for this to go to mediation? And so occasionally you'll see a contact point that might say, okay, yes, there's a harm. Yes, you have an interest. But for some reason, the contact point might say it's not useful. We don't see this as useful to get these particular parties together, or might be, well, this issue has already been addressed in previous complaints. So explaining what the guidelines expects in this particular instance wouldn't progress things. So there's I guess different ways in which NCPs have sometimes addressed that question. I don't know if that'll help, but that's particularly, I'd say particularly look at that criteria 6. That's something to look at, and you want to find a way of, if I were submitting a complaint to an NCP, find a way to explain to them why is it important or helping the effectiveness of the guidelines for this particular complaint to be picked up, and for the NCP to help that engagement. I just saw.
Laura, sorry, I was going to note also, John, that if you have a complaint where it's submitted to an NCP and they make that judgment under the 6th criteria, it should be very transparent that they've done that and the reasons why. It should be in a published final statement where they explain the admissibility, apply the admissibility criteria, and explain why it was that they didn't think it was, consistent with it, improving the effectiveness and promoting the guidelines.
Okay. That's great, thank you. Now, there's a question about supply chain, which has been partly answered in the chat, but it links to perhaps to another question too, which is that supply chains can cross, often do, a number of adhering countries or OECD member countries. Do you have any guidance about where a complainant would submit a complaint in the case of supply chain that's spread over a number of different countries?
I would, and maybe the useful thing here is for Pilku to talk a little bit more about that POSCO complaint, because I think that's a really good example of investors. So some sort of link in that value chain in Norway and in the Netherlands, where there was questions of their responsibility and what are they doing in relation to that supply chain, even though the harms were in India, a country that is not an adherent, doesn't have an NCP. And so the complaint didn't go to the Indian NCP, it went to the Korean NCP about the company, and the Dutch and the Norwegian NCPs about the investors. So I don't know, Pilku, perhaps you can talk a little bit about how to use that process for supply chain issues.
16 to 19, 22 to 23, 23 to 25.
Yeah, I mean, if the investors or buyers or the shareholders, I mean, if different countries involved, different OECD countries involved, we are trying to kind of analyze the status of NCPs in those countries. And very often, in most cases, they are much better than Korean NCP. So we try to file the case, at the same time on different NCPs sometimes. And I mean, some NCPs are very serious. I mean, we notice, especially Norwegian NCP and Dutch NCP, they are very serious. And we had some kind of joint meetings and joint discussions. And sometimes, so it's helpful to identify all these different kind of, if one supply chain related all different stakeholders or companies, and try to find out ways to kind of expand this advocacy work.
She was not well, then she was also on 31st January. She was sick.
Quick reminder for me to unmute and for others to mute, maybe. Thank you. That's terrific. So now we picked up all of the questions. I note the suggestion from Serena that we need to go more into the supply chains. We probably don't have time for it in this webinar, but it might be a very good focus for one of the next two webinars that we have agreed to have as part of this series. Are there questions that we should be getting to that we haven't addressed this time? If anybody would like to put their hand up.
Sorry, just
great.
one question I asked about this. What are the procedures? I mean, how do you analyze cases in the initial assessment stage? I mean, do you interview the stakeholders or complainants? Yeah, things like that. Thank you.
Sorry. Okay. So for the AusNCP, no, it's very rare that we would do anything more than look at the papers, because the initial assessment stage shouldn't be trying to sort of find that resolution. Often it'll be fairly quick to say, look, have the basics been shown? If yes, then let's go into good offices and use the flexibility there. And give a bit more, I guess, assurance to the company about confidentiality, how that can occur, and then start working on the issues there. And again, I don't think I'm speaking out of school, but there have been times where perhaps in my initial assessment, I'd get into all this lengthy detail, and the governance advisory board would say to me, and commenting on my draft, you don't need to, don't be making decisions now here, because the parties may engage and have their views on these issues. So it's rare that we would be interviewing or putting resources in at that initial assessment stage. But the Secretariat sometimes, Laura, will often, you know, many times where you'll go back to a notifier perhaps to ask for a bit more information or.
Yeah, I guess there's a couple of kind of strands to this. One is we always offer to meet with both a notifier and the company, because a lot of the time it might be their first NCP complaint, they're not familiar with the process, and we find that we can have a relatively informal discussion with them about what to expect. And for a notifier, that might mean explaining about what might be needed to support a complaint. Because often, you know, some people might come to us, particularly individuals, and just say, I have a problem. And we'll talk to them about these are the types of things you need to do. But just going to John's point about occasionally an examiner might talk to both parties during an initial assessment, if that is going to be an efficient and useful way of resolving the issues. But the AusNCP also has a relatively low bar for acceptance. So if you have a look at our procedures, we describe, I guess, an issue being material and substantiated as being plausible. So I guess we're not looking for volumes of evidence in that initial assessment stage that we would need to go and gather a lot of facts from the notifiers. Certainly something is needed, but it's not kind of a forensic process to meet that bar of the issue being substantiated from our perspective, and that's quite clear in our procedures.
Thank you very much. Look, I think we're getting very close to the end of time here. There was just a quick follow-up. I think two things wanted to raise. One was, I think, Nicholas asking a follow-up to his question around Indigenous people's rights. Are there good standard recommendations that are made as part of this process that people should be looking to in relation to remedy on social or environmental harms? Are there resources that you can put people to, or any common factors? Please share in the chat if you can. Maybe something we can pick up again later. I think it's a very good question in terms of making the process fairer. There was another question also from Fiji, which we didn't get to, which is around the issue of the safety of complainants. The experience of many communities in using complaints processes or raising concerns about companies is that they then put themselves or communities at risk. And so I think it's a very big question, including for this process, and it's maybe one that we can come back to in a future webinar. But I think that's probably, if there's any quick last comments, maybe I could ask John, Laura, Pilque to make before thanking you all very much for your great presentations.
Patrick, just a quick one on that point, retribution against complainants. We're very sensitive to that. We're required to do that in our procedures, and you'll see a number of complaints we receive where the complainants are not identified. And we will say to the company, we understand who they are and they have a legitimate interest, but at this stage, we're not going to be publicising that because there may be concerns about security. And we can give a bit more detail or point to the procedures, send that through.
Great, thank you very much, John. That's very helpful. And I see Serena also, I should say thank you for your very helpful contributions also through the chat as well. Any final words, Pilque, Laura, John?
I just wanted to say thank you to everyone who kind of listened today. We're very keen that this is the start of a kind of an ongoing dialogue with the DTP alumni and their network. We look forward to doing another 2 webinars, and please let us know if you've got any ideas for how we can better promote our message and the types of guidelines issues or questions that you have that would be best for us to focus on. Thanks.
I'm also looking forward to the next webinar. Thank you.
Me too. Thanks.
Me too. So, look, I should say thank you very much to Laura and John, Pilque especially, but also say thank you to my colleagues Claire and to Matthew Coughlin, who's been with us and who's done so much work in the background to make this possible. Of course, to Serena, who's been a real guide to us in this work over many years and has a very deep commitment to this process of trying to make sure that people can find remedy for harms done by companies and to promote good business practice. So it's wonderful that you could join us, and we hope you'll come back, Serena, in whatever capacity in future webinars. We will share the recording of this webinar with everybody. We'll share all the resources that have been shared also, and we will post this on, I think, on our website too. And then we will follow up with a survey. In fact, you may already have received an evaluation survey. That's very important for us in terms of saying, what should we do for the next 2 webinars? This time goes very quickly. There is a lot of content, a lot of sharing to be done and knowledge to be gained. So we want to use the time well. We want your guidance in relation to that. And so please use that evaluation survey. If it's been a helpful process and session with you, then please join us again for the next webinar and the one after. And in the meantime, please take care, stay safe, go well, and good luck from all of us here. Thank you.
Thanks all.
Thank you.